Hi everyone, welcome to our January 2021 KML Foundation vlog. I'm Paul Snamiska and I'm your estate plan counselor. Glad to be with you today. You know, after 2020, most people were really excited for a new change with this new year. And we at the KML Foundation felt the same way, and so we're making some changes this year with the vlog and we're pretty excited about them. First of all, we changed our foundation website. Make sure you check it out. It's foundation.kmlhs.org. More importantly, we've changed the format for our vlogs every month. We're calling them our Foundation Table Talk. And I'm very happy to be able to provide some experts in the field of estate planning and finance that are going to be able to give you some insights that are going to be really informative and practical for you. Specifically today, we're going to be talking about powers of attorney. And I've got my good friend, Attorney David Streese here. David graduated from KML back in 2005, went on to college, went to Marquette for law school, and now has been practicing law for 8 years with a specialty in estate planning areas. So we're very happy to have him here. Welcome, David.
Thank you, Paul.
So tell us a little bit about powers of attorney. I know people have maybe some questions about what they are and what they do.
Sure. So powers of attorney, in my practice, I refer to these as incapacity planning documents. So these are the documents by which you designate someone to make decisions for you if you cannot make decisions for yourself. And I think that's an important point because I think a lot of people, when they think of estate planning, they think of what happens after death. They think of their will, their trust. They lose sight of the fact that a very important part of estate planning is just making sure that mechanisms are in place if and when you can't make decisions for yourself.
Okay, one question, David. People have a concern about these powers of attorney, but I understand there are two different kinds of power of attorney. How does that work?
Yep, that's correct. So there's a financial power of attorney. That's the document where you designate someone to make decisions regarding your property and finances. And then there's a separate power of attorney, the healthcare power of attorney, where you designate someone to make decisions regarding your healthcare and living placement if you're incapacitated as determined by two doctors. So two separate types of powers of attorney.
Okay, and so if somebody fills that out, are they giving up their right to their finances or healthcare decisions when they fill out that form right away?
Absolutely not. So the healthcare power of attorney document is what we call springing. And what that means is it's not activated until two doctors sign off stating that someone is incompetent to manage their financial or healthcare affairs. When it comes to the financial power of attorney, a lot of times these are drafted such that your agent can make immediate decisions for you, but they cannot act contrary to what your wishes are. Okay? Until you're determined to be incompetent, that is really more for convenience than anything else, where they still have to act in accordance with what you want. So you're not giving up any powers by virtue of signing these documents.
You refer to them as a power of attorney. Does that mean I need a lawyer?
So for drafting powers of attorney, it's strongly recommended, simply because the financial power of attorney can be prepared in so many different ways. This is not a one-size-fits-all document. There's different varieties, and you may want your agents to have certain powers. You may want agents to not have certain powers. So that's really something that should be drafted by an attorney that can engage in a dialogue with you as to what your comfort level is and what your goals are. Now, when it comes to healthcare, that's a little bit more form-driven in Wisconsin. I know a lot of my clients go online and they print a form from the Department of Health Services, and that's fine as well. But I always encourage my clients to also do a good HIPAA release, and that's something that you won't just find online. You should really have an estate planning attorney prepare that for you.
Okay. So you talked about when the form is created. When does the power of those documents end?
So the power of attorney ends at death, and that's actually something that a lot of people overlook. They think that after mom or dad passes away, they can still act, and that's not the case. So the power of attorney, even though it extends beyond someone's mental incompetence, the power itself ends at death, and that's when either your executor or personal representative in probate proceedings or the trustee of your trust would take over managing your affairs.
It sounds like these are important documents. What happens if someone doesn't have one of these?
Yeah, very good question. So what happens under those circumstances is a family member comes to an attorney and we have to go through what's called a guardianship proceeding. And that's where a circuit court judge who doesn't know you from anyone gets to decide who's going to make decisions for you, what decisions that person can make, and what decisions that person cannot make. And those proceedings are expensive, they're time-consuming, they're public. I've also seen them tear apart a lot of families. You know, a lot of families that otherwise got along great suddenly didn't get along so well when it came time to fight over who's going to make mom or dad's decisions. So that's really the repercussion of not having these in place, is you're putting it in the hands of a judge to make that decision for you and to choose someone to make those decisions for you.
David, there are people then that will create their power of attorney, and you say it's good for life. What if something changes along the way? Can they recreate or redraft a new power of attorney?
Absolutely. So I like to refer to these as living documents. And what that means is they can be modified, amended, changed at any time. So certainly if there's a family change, or if someone passes away or is unable to serve as your agent, that's a prime time where these would be updated. There are sometimes law changes that occur. For example, the power of attorney statute a couple years back was changed, and now we need very specific language to grant agents certain powers. So law changes are another reason why you'd want to revisit this. I generally counsel my clients to revisit their estate plans, including powers of attorney, every 3 to 5 years, even if there's not a substantial life event change.
Okay, good. So it sounds like, if I understand correctly, if you do good planning now, you'll probably save a lot of time, money, and frustration later.
Absolutely, and you're taking control into your own hands. You know, I always use the analogy that, you know, that judge is human. Maybe they got into a fight with their spouse that morning and they're not thinking rationally, and now you're putting it into that person's hands to decide who's going to be making your financial and healthcare decision making. So putting aside the time and expense and publicity of guardianship, you're really just rolling the dice. You know, someone who doesn't know you is deciding who's going to be that guardian.
So let me just get clarification. If someone doesn't have these powers of attorney, can they just come to you and have those drafted, or do they have to do a lot more than just this?
That's a good question. And, you know, the scope of my services is based upon what my client wants. All right. It's not uncommon to draft the powers of attorney in connection with a broader estate plan, simply because, as we discussed, the powers of attorney end at death. But if that is specifically what the client wants, maybe they already have a will or have a trust, they're just looking for a power of attorney or an update to a power of attorney, they can certainly come to my law firm or any other attorney for that purpose.
Thank you, David. This information is very practical. I think it's very useful. This isn't everything, though. And so if you don't have your own powers of attorney, I think David convinced you really should. But you might still have some questions, so give me a call or contact David directly, or maybe your own estate planning attorney, and make sure this is something that you pursue, because this is really important. Because remember, it is your life. It's your plan. It's your legacy. Thanks for joining us. We look forward to seeing you next month.